Oh, yes. Rule 60B, a rule suitable for a sua sponte motion? Yes. I thought that was somewhat interesting. The sua sponte? Popo. Now, finality in litigation has particular importance in our system of justice. It secures the peace and repose of society by settling disputes between parties. Once a court renders a judgment, it is final and binding on all parties. In fact, the doctrine of preclusion prohibits the parties in their privies from raising the future suits issues actually litigated as issues that were not litigated but have a close relationship with the original claim. However, federal rules of civil procedure allows cases to be reopened in particular circumstances. Specifically, Federal Rule of Civil Procedure 60B, Rule 60B, offers a party relief from a judgment on motion when it is inequitable to permit a judgment to stand. The rule applies only to final judgments. Thus, Rule 60B strikes at the heart of concern for resolving disputes between parties. Now, Rule 60B is significant for other reasons as well. For example, oh, look at this. What is this? Oh my gosh, Rule 60B, other examples. Now, is there some reason that no one understands? Against the potential due process violations in Link versus Wabash Railroad Company? Yes. Sua sponta motion. The court recognized that when a court exercises its inherent power under Rule 41B sua sponta, it may do so without informing the party adversely affected by such a motion and not being derogatory of the due process clause. Now, the availability of corrective remedies, such as provided in Federal Rule of Civil Procedure 60B, authorized the reopening case, which inadvisably entered, renders a lack of prior notice of less consequence. Now, I didn't know about Rule 60B. Yes. But let's say you issued a protection order in 2011 where there was no due process. Pooh. I think you could open that old court case where you decided that, well, we're just going to say the guy's crazy. Now, I'm thinking there's got to be an independent court someplace in the United States that when they know of fraud on the court, yes, that very well could cause fraud of the state because you decided to have court hearings where I wasn't given notice and opportunity to be heard, and then you decided to issue a permanent court order for support when I was homeless and she was on welfare. Yes. And then you decided that you'd imprison me for back child support without any due process after I had informed you that I did not get notice of court hearings? Yes. Now, this sua sponta, the S-U-A-S-P-O-N-T-E, it's like a Latin term for those that can open any court case where fraud is found because you did not make sure to give the individual due process. Now, let's say in 2015, you make these fucking bullshit rules, okay? Now, I'm thinking there must be a judge someplace that realizes that I'm going to sue this whole nation. I'm going to sue those that are oaths for not supporting and defending the Constitution, the Fifth Amendment and the 14th Amendment. Oh, I'm going to sue those in police departments for allowing for the crime of the use of fraud to issue court orders where there is no signature of the petitioner. Yes, I'm going to sue every fucking oath, badge, and attorney in this nation for having any knowledge of the fraud on the court as well as the fraud of the state. Now, I'm wanting my rights enforced today. Do you understand? And I want to speak to my sons. Now, why don't you really look at this sua sponte? It could be that you... Oh...